Before I testify regarding my involvement in the matter relating to IDEC that I have been asked to testify about, I have to set the record straight at the onset regarding Andrea Johnson's testimony before the Commission. Advocate Johnson told many untruths about me and my involvement in what is now known as the Mukwele case. She did not disclose that I raised concerns from the onset and repeatedly thereafter, which concerns I deal with in detail. These concerns are not limited to the Mukwele matter. I had concerns about the crime intelligence-related cases and matters relating to the National Commissioner, General Fani Masiamola. Advocate Johnson decided shortly after the Section 2813 authorization of the crime intelligence matters that all other crime intelligence matters would be ring-fenced into a project which she named Project Diversion. I do not know why she chose this name, other than that what is stated in the WhatsApps that I have provided.
Which we will get to in the chronology of events.
Correct.
Okay, the next page for paragraph 5.
Thank you. I am profoundly disturbed but not surprised by Advocate Johnson's testimony. She sought to blame me for so-called irregular or problematic processes. Let me make it clear that Advocate Johnson was in charge of Project Diversion, and in particular the Mukwele matter from the onset. I deal later with the makeup of the team, which was different to how a project or investigation team is usually constituted. It is my belief that Advocate Johnson handpicked me to be part of this project because I had successfully, or rather we had successfully investigated another Section 27 referral matter involving a high-profile individual. I also believe that Advocate Johnson picked me because she thought that I would not question or ask questions because I'm a state advocate, not a senior state advocate, not a deputy director of public prosecutions. What she did not anticipate was that Mr. Mansa Rapesu, the lead investigator, and I would question Project Diversion from the start. May I proceed? Thank you.
Continue.
Thank you. I confirm that I prepared documents on Advocate Johnson's instructions that instructions that were one, not in accordance with IDAC's standard operating procedures, which Advocate Johnson indicated to this commission did not exist. 2, the process followed in July 2023 referral. And 3, that went against my concerns when assessing the merits of the complaints by Mr. Adams. I refer in particular to the application for authorization of Section 2813 investigation that I prepared on the 5th of December 2024.
Sorry, can we just interject? Can I just interject there to deal with the issue of the standard operating procedure, which you deal with in that paragraph, which you say Advocate Johnson said does not exist? If we could ask the commissioners to go to file 10 and page 9, which is, if you can identify that document for us, and the signature on page 10.
Page 9 is the Investigating Directorate Against Corruption Operations Manual. This is disseminated via email to every person that works at IDAC. It is also re-disseminated to every staff member upon the arrival of a new staff member. So it cannot be said that there are no operating procedures or SOPs within IDAC. The
and then
signature,
page 10, yes.
page 10.
Page 10, it should be page 10. You were on 9, which was the first page of the operation, and then page 10.
The last paragraph or portion of that page 10 is the signature of Mr. Matthew Sissoko. He is the head of investigations and operations, also known as the second in charge of our office. And then thereafter is the signature of Advocate A. Johnson, Investigating Director, IDAC. Please note that the dates also indicate 16 October 2024. This is version 2.
Yes, we can see there that version 1 is 18 December 2023, and then version 2, 16 October 2024.
Correct.
And could you just briefly tell us what the operations manual deals with? We are going to deal with it in detail later when we engage you on the processes, but if you could just give us a high-level summary of the document for now.
The operational manual.
Sorry, Ms.
Am I speaking
Ramsamy.
too
Yes,
softly?
and
I apologize.
closer,
Okay.
yes.
The operational manual is supposed to, and I use the word very, supposed to, create structures in which the IDAC works. These structures are based in terms of Section 7 and 27, 28, and 29 of the NPA Act. It sets out procedures with regards to investigations, referrals from the NDPP, team constitutions, reporting lines, presentations, instructions on how presentations are supposed to be done, on briefings as and when investigations are in progress. Basically, it's the Bible of how a structure of our nature is, or IDAC's nature is supposed to work. And when I use the word supposedly, if I may, Advocate Siegel, continue, thank you. Advocate Johnson would deviate constantly. It was a situation where we had this, but she would also have her own way of doing things with different groups, different investigations, different structures. So there was a constant deviation from what was in black and white. And it was always from her office that the deviation was done. And when the deviation was done, it always came with intimidation.
Can you explain intimidation in this context?
Am I allowed to say it as we say it in the office?
Yes, please.
The nickname for Advocate Johnson in the office is flip-flop, knee-jerk.
Okay, just explain that.
You would get instructions in the morning. Can I speak from my personal experience now? Okay.
Yes, please.
You would get instructions, or you would have a conversation with Advocate Johnson in the morning, or telephonically, or via WhatsApp. And it would be just the two of you, or maybe another prosecutor and you. And you would find commonality, or you would explain the legalities, the processes. I mean, the elements of an offense changes, but the principles of law does not change. If you have a document in a murder matter, it doesn't change when you're trying to prove it in a corruption matter. So you would have those engagements with her. And then during the course of the day, there would be a conversation that would take place between Mr. Perumal and Dylan Perumal and Advocate Johnson. And the flip-flop would happen. So no matter how you explained it to her, or how the decision was made in a rational manner, it would then change according to what Mr. Perumal wanted. And my evidence will show how that affected the investigations.
And when you were engaging Advocate Johnson without Mr. Perumal, did you find that you were then speaking to somebody that was legally trained, a prosecutor? Was there that level of engagement? Yes.
When Mr. Perumal was not present or was not involved in the communication or was not influencing the decisions. Advocate Johnson was a very active legal mind. You would be able to engage, and she would speak about different things that she had done and how we can incorporate it and sections of acts. But then come Mr. Perumal, all of that is thrown out the door. And we are now doing things that we're not even supposed to be doing. And it is becoming an instruction. And Chair, from 2023, let me speak for me rather. No, I'm going to speak collectively as the prosecutors of IDAC, because we are all, majority of us are rocking in this boat. If you defy an instruction of Advocate Johnson, or you contradict her, the reign or the wrath, if you have to, may I speak about, if you have to go and check the records at the wellness program that NPA provides for its employees with regards to just work stress, home stress, counseling, you will be shocked at the amount of prosecutors and employees, admin staff from IDAC that are receiving counseling.
Is that not because of the nature of the work you do? Just explain.
No, Commissioner.
Yeah, please explain.
May I deviate? Am I allowed to deviate?
Slightly.
Slightly, okay. If you don't follow the instructions, you receive emails of a nature that, when I was consulting with the DPCI officer, when I intended on making protected disclosure in June last year, I likened it to being treated worse than scullery maid. You would be internally investigated, unlawfully so. You would be made, I was made redundant for an entire period in 2023 because I objected to Mr. Perumal and Advocate Johnson. And it happened again this year because I objected.
And when you say internal investigations, what mechanisms would she adopt?
Okay, now I'm jumping ahead of my evidence, I apologize. Section 28 does not have any checks and balances. And it can be likened to a 205, a Section 205 of the Criminal Procedure Act. It's invasive. It's exceptionally invasive. But Section 205 of the Criminal Procedure Act allows for a person to make submissions to a magistrate or a judge to explain why we are now invading this person's privacy, or we need this information. Section 28 allows unlimited control by one person without any checks or balances. And that is how we were investigated, through that.
Except, of course, that even if in Section 28 itself there may be no specific provisions, the Constitution is an overarching document. So Section 28 would still have to be applied with the Constitution or the privacy right in mind, if you see what I mean.
Correct, and
Yes.
my evidence, not very far down the pages, does deal with how this is so severely abused and how it continued since my start at the ID to be abused. Sorry, Advocate.
No, that's fine.
Still on this, on the operations manual, the impression, I don't know if it's just me, but the impression that I gained from Advocate Johnson's evidence about this, the existence and application of an operations manual, was that, yes, there is such a document, but we don't operate according to it. So the impression I had was, it's sitting somewhere in a computer or on your mainframe, but in fact, it's more, you just go about doing your things, and people exercise their discretion at any one time in meetings without this ever being applied. Is that correct? Because you speak of it as a deviation. In your testimony, you say she deviated from what this prescribed. Is that deviation as a matter of course? That's what happened, and therefore this was just good on paper for all intents and purposes?
It's applied as and when Advocate Johnson wanted to use it.
All right, I'm answered. Thank you.
Okay, we can go back to your statement, paragraph 6. The sixth line, the sentence that starts, I will explain. I will explain why this did not sit well with me.
Page 3.
Yes, page 3, paragraph 6. You'll see after you deal with the 3 points, you then say, I refer in particular to the application for authorization. Do you have that?
Yes.
You can read from there.
I refer in particular to the application for authorization of a Section 2813 investigation that I prepared on the 5th of December 2024. I will explain why this did not sit well with me. However, the commissioners must bear in mind that at this point, Advocate Johnson had stated they had made a decision that the matter was to proceed in terms of Section 2813, and that I was to draft the authorization and email it to her on the same day that the referral was handed to me, because she wanted to approve it by Friday, the 6th of December 2024. I deal with this fully later in the statement.
Continue.
On or about the 30th of June 2025, after the Mokwela arrest and the first appearance, I contacted a DPCI officer. I must state I trust this DPCI officer, which is why I contacted him, to inform him that there's a problem at IDAC and that I need to see him and explain and show him the documentation that I had in my possession. I asked if I could if I could do protected disclosure. We agreed to meet on the 2nd of July 2025, where I showed him a prosecutorial memo prepared by me and another prosecutor regarding the matter of General Masiamula and Lieutenant General Kumalo, which I deal with later. He said that he would speak to a colonel at the DPCI and get back to me as to how we were to proceed. The reason that I contacted DPCI is because I had previously, in late April 2025, informed Advocate Santos Manila, the DDPP that I report to, of the discord amongst the team being that of the crime intelligence investigation, and that the investigation procedures were being flouted and that the investigation was sloppy. He replied that he had his own problems. In August 2025, I started collating documents regarding what I considered to be unlawful instructions from Advocate Johnson and Mr. Perumal regarding project diversion. May I proceed?
Ms. Ramsamy, sorry. When Advocate Manilal says he has his own problems, was it about the same issue, the crime intelligence investigation, or?
He had not, although he was on paper as the deputy director, he had not been briefed on the matter, which I do discuss later on in the statement.
The question I'm asking is, when he said he has his own problems, did you understand him to mean about the same subject, the same investigation, or he had his own problems within IDEC? I'm just trying to understand what it is he was.
I understood it to mean that he was not interested in my problems and this
I
project.
see. Yes, thank you. That answers me. Thank you.
Okay, continue.
On the 8th of August 2025, Advocate Peter Surunye, a Deputy Director of Public Prosecution, came on board the Mokwele and Lushaba cases. He started sending emails and memoranda that accorded with my concerns on how the Mokwele matter was being conducted. Advocate Joy Swayo and I also approached Advocate Surunye with our concerns. He can confirm this to the Commission. When Advocate Surunye requested to be removed from the Mokwele and Lushaba cases, I was removed from the Mokwele case, and although I was apparently kept on the Lushaba case, I was excluded from the case from September 2025. I also approached another deputy director and showed him all the documentation that were concerning. He stated, "These things will never come to light." In November 2025, after Advocate Johnson testified at the ad hoc committee, I contacted the same officer at the DPCI. I informed him that Advocate Johnson had lied to the ad hoc committee and that I had proof of this. Once the new NDPP, Advocate Matibi, was appointed, I met with the DPCI officer. This would have been around March 2026.
Can I just interject to ask you why it's significant that you mention once the new NDPP was appointed? Did you meet with the DPCI officer?
Because I knew that if I had reported or we had taken these concerns to this then sitting NDPP, nothing would have been done. Advocate Johnson, there would be no repercussions, there would be no corrective measures.
By that you mean Advocate Shamila Batohi?
Correct.
Why would you have formed that opinion?
I was aware of the matter that was discussed with the Commission about the sharing of documents, but that was corridor talk, so I wasn't confirmed. But if I may put it frankly, from a prosecutor's point of view that's in the office every day, Advocate Johnson was the blue-eyed girl of Advocate Batohi. She could do no wrong. If needs be, or if the Commission so sees fit, if you look at any grievance that was sent about IDAC from the staff members, it was squashed to an extent where people started just resigning. People were applying for posts. I'm an SA. I've been applying for SA posts just to get out of that unit.
And you refer to the sharing of documents. Are you talking about what Mr. Ruloff said, Mr. McLean, and Witness O said about the sharing of a docket by Advocate Johnson with General Khan? Is that what you are referring to?
Correct, but at that time, before the testimony, it was just corridor gossip.
Thank you, thank you.
Thank you.
Before you move on to the next paragraph, at the end of that paragraph 9, this is the prosecutors, after you show him documents, the DDPP, and he said these things will never see the light of day. What did you understand by that? That they will be destroyed, they will be suppressed? What exactly did you
That no one
understand?
will ever know that these things were done by Advocate Johnson or at IDAC.
So it would be suppressed.
Correct.
Okay. Paragraph 11 on page 5.
I mention this because I do not want the narrative to be that I am retaliating against Advocate Johnson for making me the scapegoat, or that I am coming forward with this information now that my name has been dragged through the mud.